see that the numbers are slowly trickling in. I'm just going to put it off now before we get started, and once I've done, I'll hand it over to Stephen. So good morning, my name is Haifa. I'm a marketing assistant here at InfoTrack. Welcome to today's webinar, where we'll be hearing about some unique insight into the key factors residential law firms must be aware of to meet due diligence requirements and ensure their clients are completely informed when it comes to climate change. Taking you through today's webinar, I'm delighted to be joined by Stephen Sykes, who is an environmental lawyer at Capital Law. He will be taking you through this webinar today. Before we begin the webinar, just drawing your attention to the Q&A tab, which is located at the bottom of your screen. We will be running a Q&A at the end of the session, so please type any questions you might have for Stephen along with your name into the Q&A box. That way, if we run out of time or your question requires further clarification, we will extract your information and follow up with you directly after the webinar. Thank you. Handing you over now to Stephen.
Yeah, thanks, Haifa, and good morning, everyone. Really looking forward to the next hour. The takeaways for you by the time we're done will be a sense, hopefully, of the scale of the impacts of climate change on UK real estate. It may come as a bit of a surprise as to what these impacts look like, but we'll be spelling those out in clear detail and giving you a sense of just how many properties are at risk over the coming decades from a warmer climate. A warmer, and I should say a wetter climate, because that's really what climate change is going to do to the UK. More rain means more flooding, and warmer conditions such as the ones we went through in the summer where we hit 40 degrees means more subsidence, more land instability and more extreme weather events. So it does have an impact on property, but it's quite rare, I think, for those impacts to be spelt out. So I'll definitely walk you through that. And then critically, and I think quite central to this presentation, is understanding the legal duties that conveyancers face, residential conveyancers, commercial property lawyers as well, to warn clients about these risks. I describe this as an evolving area of law in which professional guidance is coming together now, but I think it's really important to understand just what we've got to do to discharge that duty. And critical to that is the availability of climate searches, not separate searches, integrated into your existing environmental search as a new component. That's how this is panning out. So it's not the most onerous of tasks to satisfy this duty. I don't want anybody panicking about this. It's relatively straightforward, but I will walk you through that and what you have to do to comply. Next slide, please. So here are some numbers. As I mentioned, my background is environmental law, so I used to be the chair of the UK Environmental Law Association. Looking at the kind of risks that you'll come across from time to time, land contamination, flood risk, if you like. That's almost like looking in the rear mirror, impacts from historical land usage, impacts based on the climate as it is today. If you like, climate risk is actually the same sort of geophysical impacts, the same property impacts, but based on a warming climate, looking through the front mirror, if I can put it that way. And the principal risks of concern to, I think, us as conveyancers and certainly to property lenders are on this slide. So you see coastal erosion there. At the moment, we've probably got about 10 to 11,000 properties at risk from coastal erosion. But if we get these extreme weather events, storm surges and the like, and impacts on coast, particularly on the east coast, parts of the south coast, where the geology is sort of more fragile, those numbers grow quite substantially, you'll see, by 2050. And of course, if there's a property impacted by coastal erosion, it's not a marginal risk. It could mean the property is uninhabitable. It could mean it actually disappears into the sea. There's all kinds of repercussions. So even though not huge numbers of properties are at risk, they're not insignificant. And it's important, I think, to be mindful of the direction of travel that we're on with these numbers. The other one to flag, which affects far more properties, is subsidence, principally for residential properties built on clay. particularly around London, North London and the southeast. A lot of properties are built on the London clay there. When you have temperatures along the lines of what we've just been through this summer at 40 degrees, there'll be a lot more subsidence, a lot more cracking, and some of those problems are resolvable but at a cost. And occasionally some properties with extreme subsidence, it can be quite a challenge. But you see the numbers there. That's why I put them up for you so you can take it away and reflect on it. Is a quadrupling by 2050. These are predictions from Groundsure. They've been analysing this sort of data for 20 years. They're very good at what they do. The underpinning data comes from the Met Office and the British Geological Survey. These are highly credible organisations, and they provide the data. And Groundsure number crunch it and come up with these projections. And then we see three different types of flooding, from rivers, from surface water, sort of flash flooding, and from coastal flooding. And you see a similar sort of trajectory, that a warmer, wetter climate means more properties at risk, and the numbers are significant, bordering on concerning. This is on the basis that our climate change increases temperatures by 1.7 degrees, which is the number the Bank of England is using at the moment as perhaps the most credible, but it could be higher than that. So this is not meant to be alarmist, it's factual and scientific and based on the best projections that we've got at the moment. Next slide, please. So I helped organise an event, a climate change conference for conveyancers at the Law Society in June, and invited along Tyrone Dunbar, who is the link between the Met Office and the Cabinet Office, because this is one of those risks. Climate change is one of those risks that the Cabinet monitor from time to time. And Tyrone said, well, look, Stephen, the way perhaps to get these points across is I'll run a weather forecast for 2050 and the kind of weather we might be expecting in a few decades time based on the projections that we're on, particularly where you get a heat dome that sits over the country, traps the heat, and what might the temperatures be. This was in June, and everyone in the room was looking at this thinking, well, yes, concerning, because 40 degrees is 105, 106 degrees Fahrenheit. We're not used to those temperatures here. We've never had those temperatures here in recorded history. And then we went forward just a few weeks, and this came as a bit of a shock. But yes, those temperatures were being experienced. We had the first time the UK's had 40 degrees centigrade, and more recently, Met Office stats are showing that there are certain parts of the UK that are 5 degrees centigrade warmer than they've ever been, which is, of course, definitely cause for concern, and as we'll see shortly, drives impacts on property, on houses in particular. So this is, without wishing to cause panic, it is a cause for concern. Climate change doesn't mean sort of a uniform increase in temperature across the whole of the UK. There are spikes in certain areas depending on local climate, but you can see the impacts there. Next slide, please. So how certainly the Bank of England typically talks about, or climate professionals talk about climate risk, is typically in two categories: physical risks and what we call transition risks, which I'll come on to in a moment. Physical risks are, what impacts will a warmer, wetter climate have on the land? What are those physical impacts? And we've given some examples of them. There are quite a few potentially. I mean, we had wildfires affecting properties in East London during that the high heat that we had in the summer. That's a physical risk. A physical risk could be impacts on the ability to abstract water. If a residential property draws water from wells, and quite a few do across the UK, particularly in the south. So that's the whole category of physical risks. Flooding would be one, and coastal erosion, the examples I've given previously. If you look at this slide, though, the stat I wanted to draw your attention to comes from a loss adjuster, Sedgwick, for the summer we've just had, and sure enough, they are saying that this will be, not in a good way, a bumpy year for claims against property insurers for subsidence. And you can see the numbers, a trebling or a quadrupling of claims for subsidence, particularly in the south east and in North London. So we are seeing these impacts. It's not, with climate change, it can seem overwhelming for quite a few of us, quite daunting, is something we always want to shut our eyes to, because it's such a massive overarching issue. What I'm trying to get at is, let's open our eyes and look calmly at what's happening, try and adapt to it, but also as lawyers be mindful of what the impacts are for our clients. And this is one snapshot where a warmer climate will have these kind of impacts. If the physical impacts take another form, if it is more to do with flooding or coastal erosion, then in some cases it may be that residential properties are going to be quite difficult, well, for developers, difficult to perhaps get planning permission for, in some cases, extreme cases. Also in some extreme cases, difficult to insure or to raise a mortgage on properties which are at sort of near-term climate risk. And the worst case scenario here is the coastal erosion. As we said, that's quite a special category, but where the property is lost in its entirety. Next slide, please. So here we have a shot of a good friend of mine who founded the UK Environmental Law Association, Stephen Tromans, KC, regarded widely as the leading environmental law practitioner in the UK, been practicing in this area for well over 30 years. All manner of clients that Stephen would advise over that time, house builders, the Environment Agency, and so forth. And one of the things about climate change that I was pondering as an advisor, I should say, to Groundsure, I started earlier this year, was to think through what are the responsibilities and what are the duties of conveyancers when it comes to climate change. Nobody had really given a huge amount of thought to that, albeit the Law Society for England and Wales passed a climate change resolution in October 2021 and said that they would be developing guidance for all solicitors in the UK, including solicitors involved with residential property transactions, to take us through what our professional responsibilities are. That guidance note's coming, I think, in the first quarter of 2023. We can talk about that perhaps in the Q&As, but sort of to facilitate that process and to understand what the risks are, I instructed Stephen Tromans on behalf of Groundsure in the summer to say, well, Stephen, is there a duty or isn't there? No particular spin on that question. It was just objective to see what he thought, given the sort of numbers we're looking at and pressures that are coming from lenders in this area, where they're required to carry out what's called stress tests on their portfolio of properties. It all seemed to be coming to a bit of a head, but nobody looked at what the actual duties of solicitors were. So that's why I asked Stephen to advise, and the next few slides take you through the essence of his advice. Next slide, please. So I asked Stephen in particular, what are our professional duties? And my brief and his full advice, which is about 3,500 words, but also there's a one-pager which I summarised for him and which he's happy with. That's included on Groundshure's website. You can download it. Certainly read the one page. If you've got time, read the whole opinion. It was written with solicitors and licensed conveyancers in mind. And it was very much, is there a duty? And if there is, what should we do about it? What are the practical steps that we should take? And it is a seriously important piece of advice. I would say Stephen's not the only senior lawyer to look into this. We'll come on to it later on in the presentation, but there was a general counsel, a very experienced for one of the big city firms, looked at it sort of separately from Stephen and a bit earlier this year and reached pretty well the same conclusion. And that is, in a nutshell, that we have a duty, yes, a duty of care, but really a duty to warn our clients about climate risk impacts on property. That's what Stephen is saying. And to be sure, there isn't a specific case, High Court, Court of Appeal, Supreme Court, there's no specific case saying that this obligation exists. It's a tortious duty drawn from analogous case law, medical case law. You'll see it all on the opinion, which is sort of built up where Stephen argues quite convincingly that this duty does exist. I have to say, in the interest of trying to be even-handed about it, I tried personally to run a counter-argument to what Stephen was saying, to think, okay, is there a case for saying there's no duty of care? And I found that a pretty difficult argument to run. I've not seen anyone that's disagreeing with what Stephen's advised, and that opinion's been available on the website since July. What was interesting was Stephen said that when it comes to the duty of care and the duty to warn for solicitors, there's no difference between a solicitor and a licensed conveyancer. There's not much case law on licensed conveyancers in this space, but he said the duty is comparable, and it comes from our general duty to exercise reasonable skill and care. What would a non-negligent solicitor do in a property transaction, mindful of climate impacts that can affect real estate, as we've seen, the physical risks, the increased flooding, the substance. When you have that sort of knowledge, what should you do with it? And he said this general duty to exercise reasonable skill and care applies to other risks that can have an adverse impact on the property being purchased, and certainly climate risk is in that category. Actually, if you look at the numbers, there's a lot of properties in the UK at risk from flooding. I mean, millions. I think the Environment Agency said the number's about 5.2 million, given the current climate is within the UK. Factor in climate change as well, and it grows by several 100,000. So climate risk is putting a lot of properties into a sort of exposed category, not to the point that I want you panicking, because I would say Groundsure have been running their ClimateIndex search for residential conveyances since June on tens and tens of thousands of properties, and it's about 1 to 2% of the sites are, if you like, failing or not passing the climate test. So 98% of the time there's no issue, but in probably about one or two out of 50 there is. By the time we finish the presentation, I'll explain what you need to do about that. Next slide, please. This is also part of Stephen's rationale Stephen Truman's rationale in reaching the opinion that he reached. As conveyancers and property lawyers, you know, our job is, yes, to understand title, to understand property, and to understand risks. And his view is, if you take what he called a layperson, but really a home buyer, no one probably would have explained these issues to home buyers. It's not something that they would particularly understand. Whereas conveyancers, you know, we are in that slightly different position of understanding property-related risks. And his view is that a conveyancer should be aware of climate risks, particularly given the scale. It's not that these are, you know, so marginal that we're talking a handful of properties at risk across the UK in the coming decades. We're talking about thousands and thousands of properties that may be at risk. So Stephen's point was that conveyancers should, as part of the retainer, take steps to warn the home buyer and to advise on how then to respond to this risk. And that's the same tack we'll see that the General Counsel, Sarah De Gay at Slaughter and May takes. This is primarily a duty to warn. It's also actually a duty for those of us who are solicitors, it's a duty to disclose material information which we encounter during our brief. Even if it's actually beyond the retainer, we encounter information in the course of acting for a client, such as a negative climate report, or even a positive climate report, more so, to relay that information to the client. That's what we should do. Stephen did say that the duty of care, the duty to warn is client specific. If you're acting for, which not everyone on this call isn't, but if you were acting for an experienced commercial client, property client, that's got, say, its in-house sustainability team, etc., even in those cases, the duty applies, but you don't have to do so much to satisfy it. But in the case of home buyer, where the knowledge doesn't exist to the same degree, the onus is all the more on us to take the client through these issues. So it's sort of fact specific, client specific, but the duty is there, and it's a responsibility we need to take seriously. Next slide. So in the presentations I've given, certainly when people have gone away and looked at the underlying law, there's no real dissension. People aren't saying, well, hold on, this is nonsense, particularly given that the caliber of the people that are telling us this are highly regarded, respected lawyers. So the next part of the presentation proceeds on the basis that the duty to warn exists. We have this duty. What do we do about it? what Stephen says in his opinion is that what's really quite central to this duty to warn is the existence of a solution, quite an easy solution that's available to us as conveyancers. In the case of Groundsure, there's a product called the ClimateIndex product, which is there's no additional charge. It's not a separate search. It's integrated into the home buyer's environmental search, and it is basically a site-specific climate search that takes Met Office, BGS, and flood risk data for the next 30 years, and basically assesses whether a specific property is at deteriorating risk during that time frame or not. Now, if a tool like that didn't exist, and that's an incredibly powerful tool to help clients make better informed decisions, but if it didn't exist, then the duty of care or the duty to warn would be in some ways a little pointless, because you wouldn't be able to provide meaningful advice to the client. But it's almost as if the existence of the tool, together with the underlying law and what the Law Society is doing, and what lenders are doing, actually before Groundsure got interested in this area, all that's has sort of come together to mean that there is now a very easy step that we can take to discharge this duty of care. And what Stephen says, the first thing that we should do is understand what a climate search looks like. As I say, in the case of Groundsure, it's just a module on the front page of the report. It's almost like a tick box. If the site is not at climate risk, you'll be familiar with a sort of a traffic light type system. It will get a green light, it'll get a go. So he's saying the first step to satisfy the duty to warn is understand this tool. That's what you should do, and then advise the client on the need for it. There's no additional cost for the client in the case of the Groundsure tool, so that makes it even easier to ascertain. What he also goes on to say, and I think this is important, is that because I'm aware as a working with property lawyers myself, is that sometimes when searches are obtained, they're simply forwarded on to the client. In the ideal world, they should be sent to the client with a summary as to whether the property has passed or failed, and then you should take instructions, not simply forward with no comment. Stephen's view that's not sufficient to satisfy the duty to warn. You've got to explain what the report's about, what the results were about, in relatively simple terms. And Groundsure are developing standard wording for that, for inclusion in certificates and reports on title. Been working on that with a round table of property lawyers. Next slide, please. So you might think, where has all this come from? I mean, climate change has been building up for decades. The science is incontrovertible now. I think 99% of scientists around the world agree that the numbers are what they are. We're 1.1 to 1.2 degrees warmer than we were in the pre-industrial age, and we're heading to 1.7, potentially more than that over time. And it has repercussions for all of us, including the lending community. And under Mark Carney, the former governor of the Bank of England, back in 2019, in a fairly far-sighted way, he could see that ultimately climate change can affect property value and can affect bank security and can create credit risks. So right back then, there was a requirement for banks to try and get a handle on this risk, because it's not something that's minor. And the way you manage a risk is you measure it, you put a number on it. So what then started was banks buying climate data from companies like Groundsure. I think three of the biggest banks have been buying climate data from Groundsure for some time now to help satisfy this duty and to understand these risks more generally, and to conduct what's called a climate stress test on their balance sheet, particularly on their back book of portfolio. And the numbers are there. So read those numbers. Basically, a credit risk exposure of 225 billion. Potentially by 2050 for banks, with quite a lot of UK homes becoming uninsurable. We've got flood re to rely on, I think, until 2039, but after that we don't really know. So there's pressure being exerted on lenders. They're alive to this risk. Barclays regard flooding and subsidence as two of the biggest climate impact risks in their environmental report. So lenders are getting up to speed with all this. think they're actively looking at the lender's handbook now to see what that should say about climate searches. So we have to get ready for what may be coming our way, either required and enforced by lenders, or, if you like, as a market pressure, or by PI insurers as a market form of market regulation. But we've got the cautious duty anyway, which is inclining us to do something about this, not to sort of ignore it. And also in Stephen's Troman's opinion, you have the reference to the case, the Bowerman case, which is that if in the course of acting for a lender, we encounter information that is material to the lender's security, and climate risk would be, we have to pass that information on. So there's a whole series of different factors here, which, if you like, conspire together to require us to do something. And that something is understanding our duty, modifying our standard documentation to some degree. I can address that in Q&As if that's going to be helpful, and also understanding climate searches, but not panicking, because I don't think the exercise is all that onerous to satisfy this duty of care. Right, next slide, please. So, Climate Index, what does it look like? Some of you will be familiar with Groundshure's reports and the key factors and results that they look at. So they've been modelling these forward-looking physical risks I've been talking about, different forms of flooding, ground instability, coastal erosion. They now have a rating product to assess the risk to 2050, which is aligned to the Bank of England stress testing we just talked about. So not looking too far beyond that, and running a 1.7 degree climate warming increase into that model. There are some businesses in this space that are running a 4 degree climate warming model, which creates, you know, a lot of sites will be at risk and probably unnecessarily blighted with that sort of projection. So 1.7 is more moderate and more realistic, and aligned to Bank of England and Prudential, the PRA considerations too. So this risk rating, you can see, you get a view, the current view on the bottom right hand side there, of what the risk is at the moment. The climate index risk at year 1 is a B risk, and there's links through to the Groundshure's website and FAQs to explain all this, and a helpline if anyone was uncertain about it. You may see over time a particular risk increasing, so that 30 years you go from a B to a D, and Groundsure there to explain, okay, what might the next steps be at that time. What I'm hearing, as I say, is that I think 96 to 98% the risk stays the same. It doesn't increase over time, and in each case you just have to say, in effect, it's passed the climate search test. That's what's happened. Next slide, please. That's a little bit more detail to, as you see, if you look over to the right hand side there, taking those key physical risks of the flooding risks, the ground instability risks, coastal erosion, where the coast is defended by infrastructure, for instance, by the Environment Agency, and cases where it isn't. One thing I would say on that is that there's no absolute obligation, no statutory duty on the Environment Agency to defend our coast. No absolute steadfast duty, it's a discretion. And they bid for funding, or funding is allocated them on, I think, a 5-yearly horizon. So in the long run, it's hard to say for sure, or to assume, it would be dangerous to assume that existing flood defences, river defences will be maintained and enhanced ad infinitum. Certainly some of the work I'm doing for Capital Law, which is one of the firms I work with in South Wales, the planning guidance there is, it talks about managed retreat. There'll be areas of land that are not economic to defend, and there'll be properties there that will be exposed to impact over time. So you see, for instance, coastal erosion undefended, a low risk at year 1, but by the time you get to year 30, a significant increase in that risk, and that may impact insurability, mortgageability, and the like. Next slide, please. So we've got this question, you get yourself familiar with climate search, you participate in a seminar like this, or you have some training from Groundsure, which I'm sure they'll be happy to provide. There's lots of blogs, there's lots of data available, and there's a microsite being developed to help solicitors and conveyancers understand these issues, and a helpline. But when you're familiar with the information, what do you do with it? So that's what I asked Stephen Tromans in the brief. And there's a case on this, actually called the Bird and Bird case from a few years ago, where in the High Court, it was actually a discretionary planning search, which a law firm had commissioned and sat on. But the High Court judge said, look, in the case of searches of this nature, a non-negligent solicitor would have done the following. They would have summarised the purpose of the report. They'd have summarised what the report found, the key results. And they would have said if any more information is sought, where they could go to get that additional information, and then they ask for instructions. And that sort of approach is what a non-negligent lawyer would do in the event not just of a planning search, but any kind of environmental search and flood risk or contaminated land, explaining the purpose, go through the results, and then take instructions. That's the sort of broad approach, not simply send it off as a PDF and leave the client adrift to make their own decision. Next slide, please. So what Stephen Troman's opinion also talks about is that none of us are climate scientists. We're not climate specialists. We're property lawyers. There's a limit to what we actually know. But there are times where I was going to say we phone a friend, but where we talk to other specialists who know more than we know. And where would the first port of call be? Where we have a failed climate search, what would the client want to do? Well, if it's failed, one question is the property worth, is the house worth what you think, what the client thinks it's worth? And what view would a valuer take of this? So the valuer's red book is in the process of being updated, but even as it stands at the moment, there's a section in the professional valuation guidance for valuers that, in effect, in simple terms, says climate change is a material valuation consideration, and the valuer should, certainly in accordance with that guidance, be able to provide a steer as to what the impact on value will be from climate change over the medium to long term. Now, we at Groundsure had conversations with the head of valuation at the RICS to just check that that is the case. We were told there are specialist surveyors, environmental surveyors, they're the best place to give this steer, but other surveyors and valuers should be able to follow that methodology in the Red Book to give advice. They won't include climate change impact within their standard valuation, but it asks separately, specifically for the impact of climate change on a failed report. That we're told they will give that advice. And they're the first port of call, essentially, because that could lead to a price chip. It could lead to the client withdrawing from the deal in some cases. The other professional to talk to is the insurance broker, on the basis that if the climate impacts predicted for, say, 20 odd years' time were to happen today, this is a question I would ask: is the property still going to be insurable? You can't say to an insurance broker, is this property going to be insurable at 2050? They're not going to answer that. But this kind of halfway house is hypothetical. If the insurer saw a report like this as of 2023, with an increased risk of coastal erosion, flooding, or subsidence, would it be insurable, or wouldn't it? And if it would be insurable, is it at the same premium, or does the premium go up? And then, armed with that information, you can go back to the client and give them a steer. Those are the real steps that can be taken at this stage. As I say, not many transactions, conveyancers are going to need that sort of extra step, but some will. So next slide, please. Okay, so one thing I wanted to convey is what the risks are to conveyancers from the climate duty to warn and climate searches, and how to mitigate that risk. So you're doing the right thing now to participate in a training course like this. Clearly, that's very helpful for you to take a closer look at the climate searches that are available. There's only really two. There's the Groundsure search. There's a company called Dye & Durham that have a climate search, but my understanding that's a separate research and it comes at an additional cost. Whereas the Groundsure is integrated into the existing environmental search. It's just a lot easier to manage, frankly. Risks for conveyancers will be mitigated where the steps you take, you actually record them in writing. That's what the King's Council recommended. Recorded in writing, and the obvious place for that, report on title, or if you actually fill in the certificate on title. is a place where you write down, you say, we've commissioned a climate search, this property has passed or this property has not passed. If it's not passed, these are the steps that we recommend. That's really the best way to be mitigating these impacts. And if you do that, I think it's good for obviously client retention, and will be well regarded by your PI insurers, rather than you're like doing nothing about this, which is not recommended, or taking steps but not documenting them. They really do need to be written down so you can address any concerns a client might have down the line, or potentially a regulatory body might have down the line when they ask you, what did you do? And you can say, well, look, this is what we did. We wrote it down, we followed it, we had training and so forth. And then you're meeting your standard of care. So next slide is an interesting one, because I'm sure some, actually back one, please, Hafer, if you can. Excluding climate advice from the retainer. I'm absolutely aware that the residential conveyancing sector is under huge pressure around fees and workload and so forth. I'm absolutely aware of that. And this may come as yet another thing that you have to do, and another burden. Is it the straw that breaks the camel's back? And if it is, can you sort of sidestep it by saying to clients that we're just not advising on this? We're not going to advise on climate risk. What I'm trying to do is say, yes, there's more to do here, not a huge amount more, and trying to get you through that duty as simply as possible. One way not to get around the duty is to say, look, we're not advising, because there's some advice we'll see shortly that for solicitors, that could be an attempt to say, look, we're not advising on something which is a clear duty, could be a breach of regulation. And in any case, if you exclude advice from a retainer, it's only effective where you have the client's consent. And the King's Counsel Tromans says that you have to get the client's fully informed consent, which means walking them through climate change and all its manifestations and its impact on insurability and mortgages, and then saying, oh, by the way, we're not advising you on this, which is going to take a lot of time. You're not going to be able to be charged for that. You may as well, the amount of time that takes, you may as well commission the search, interpret the search, and move on, sort of job done. So excluding advice from retainer is not a recommended course of action, to put it mildly. Next slide. So I mentioned there were 2 lawyers that have looked closely at this to date. Others are looking at it for sure. Stephen Tromans, we've had a close look at what Stephen has to say. Also, Sarah DeGay. Sarah was an M&A lawyer at Slaughters, became general counsel there, and was in charge of compliance. I think one of the senior compliance lawyers at Slaughter and May. And this is, to some extent, a compliance issue. It's a risk issue for law firms and conveyancing practices. If you don't act on this, you could be exposed to negligence. And Sarah wrote 2 publications, one sort of back in March, and the other one in August. So this has been going on for some time. And her March advice, particularly the August advice, was about solicitors generally, not just real estate lawyers, but I think it extends also to conveyancers essentially. And it was, what duty do you have to advise your clients on climate risk? And independently of Stephen Tromans and before Stephen Tromans, she reached the view that emphatically, albeit it's fact specific, that there is an obligation, a duty to warn and clients about climate risk, and a duty to disclose material information to clients which you uncover during the course of the transaction, which would include climate risk. So those duties are there. They're twin duties. The thing about the duty to warn is that it's not just the knowledge that you actually have that you have to disclose, is the knowledge that you ought to have had and you're not being negligent that you ought to disclose. So it's sort of more like an objective standard. And just to say, look, I didn't know, I didn't commission a report, you're like, it's nothing to do with me, that's not sufficient to satisfy this duty. So Sarah's credentials speak for themselves. I've had communications with her and they're very impressed, and broadly she takes a similar view, as I say, to Stephen Tromans. Next slide summarises this in a little bit more detail. You can see she's saying definitively and resoundingly, yes, we have to we have to deal with this. We can't ignore this. We have to give this advice. The advice is to disclose material information. The advice is to warn about obvious legal and commercial risks, and that definitely includes climate risk impacts. So there you have it. That's Sarah. She wasn't commissioned by Groundsure. She did it independently. She reached that opinion. Stephen was commissioned by Groundsure, but had he taken a different view, that would have been what it would have been, but he didn't. So you have these twin pillars of legal authority reaching this view. And then, as I've tried to take you through, it is okay, what do you then do to discharge that duty of care? And that's around commissioning climate searches, interpreting them, reporting them back to the client, and in those very few cases where there's a real problem, trying to price that risk, I think, for the residential property market, so that the client can at least consider a price chip, and getting a steer from valuers or other specialists to put a number on what that impact might look like, and then go from there. Next slide. So sort of in summary, and then we've got a chunk of time for questions. What have we learned? I think we've learned that climate risk is impacting property. It's doing it already. It did it this summer with thousands of properties being impacted by climate change enhanced high temperatures. I mean, 40 degrees centigrade is not normal. It may become the new normal, but it's not normal in the UK, but we're having it. And we've had, I think it's 7 or 8 of the warmest years on record have been in the past decade. So we have to open our eyes to this and figure out what it means. We've had extreme weather events in different parts of the country with impact on infrastructure and certainly on properties. So it's happening, and it affects real estate. And we work in real estate, and it's a significant risk. So what do we then do about it? Some solicitors for sure, and conveyancers for sure, are thinking, look, this is really all for the surveyor. It's nothing to really do with us. The surveyor can step in and advise on it. And sure enough, surveyors will have their own responsibilities. But we can't sidestep it that easily, because as the King's Council advice shows, and Sarah De Gay and work that the Law Society is doing, which I can certainly shine a light on, we have our duties too. And their duties to warn clients in a careful way as to what these risks are. And we can discharge that quite simply by commissioning an environmental report that includes the climate module on page 1. And if it has a pass, we say it's passed. If it hasn't passed, we explain why. That's the step to take. There's no extra cost for that. It's a reasonable step to take. And if we don't take it, then we're potentially exposing ourselves to all kinds of repercussions, including professional negligence in some cases. If a client does acquire a site or sites and incurs a loss, then they may be looking for someone to blame. If these reports are there, they've been available since June the 28th when Groundsure launched its report, they'll be asking, well, why didn't you commission one of those? It was a very easy step to take. It didn't cost any money. It's not an additional report. Why didn't you do it? It's a sort of position I wouldn't want you to be in, because you'd then find yourself on the back, very much on the back foot. So that's really the essence of what I wanted to say, and can absolutely open up the floor now to any questions you might have. Stunned silence.
Thank you, Stephen. So yeah, we have had a few questions, so I'm going to jump straight right into the Q&A session now. One of the questions that we have is, what is the Law Society doing about this? Okay, so the Law Society, you may know, is organised in a number of subgroups, to some extent specialist subgroups, and in 2020 they set up a climate change working group, the CCWG, chaired by Caroline May at Norton Rose. Was a big team of lawyers involved in that subgroup. They issued the Law Society issued a climate change resolution in October 2021 that said, you know, we need to step up the plate. We've got responsibilities in this area. We have duties, and actually that they will be producing guidance, that working group will be producing guidance for solicitors across the board, not just conveyancers, but for all of us, essentially. So if you like, the writing was on the wall a year ago that something was brewing and will be coming our way. And in the intervening period, that group has produced a draft practice note that was out for consultation to various bodies, including the City of London Law Society. The UK Environmental Law Association, which I used to chair, received a copy in August and responded to it.
I think the next iteration of that guidance is coming, and that includes checklists and what you need to do to comply with this, and refers to duties and refers to climate searches and the like. It's not out yet, so we have to wait and see. But that group is doing exactly what it said it was going to do, and it's got some very good people on it. That's overarching guidance for us as lawyers, both in our capacities, in some cases people that run law firms and run businesses, and what those businesses should be doing about climate. There's information about that in the practice note, but there's more granular guidance around specific areas of practice. It's not just about real estate, it's all many areas of law. The same duty to warn actually applies in M&A, construction, so many other areas. So that piece is going on. Pause for breath. There's also the Law Society has other specialist groups. There's a conveyancing law committee. There is a planning and environmental law committee that's run by Sebastian Charles, who heads up a environmental and planning firm called Aardvark Planning Law, and he's been working on a real estate specific practice note, or that group's been working on a real estate specific practice note, I think in concert with the Climate Change Working Group and with the Conveyancing Law Committee as well. I'm not that close to that. I've not seen that in any detail, but that is emerging, and I think it's hard for me to put a time frame on it exactly when because there's a process it has to go through to be approved. But you're seeing two parts of the Law Society sort of working in tandem to move the profession forward with some professional guidance. So you take that into account with what the pressure on the banks and the pressure they might be exerting through the handbook, these tortious responsibilities, availability of climate data. And I know, conscious there's a lot of discussion about this at the moment. It's, like I say, it's all coming to something of sort of crescendo. If a practice note comes in, we're not absolutely obliged, those of us who are solicitors, to follow it. It's not absolutely mandatory, but we'd be pretty silly not to, because it's the easiest way to show that we've discharged our duty of care. And if a body like the SRA comes knocking on our door saying, well, okay, there's a problem with this transaction, what do you do? But we can say, look, we follow the practice note, like we do for, say, contaminated land or flooding, then by and large, we're in the clear. If we fall short of that, then we've got a problem. And that could hit all kinds of repercussions, particularly PI, which I know is astoundingly high for us anyway, particularly those in real estate practice. So there's a lot of activity within the Law Society in this space, and yeah, there will be guidance coming our way.
Wonderful, thank you. Another question we have from our audience is, when does one say the property has failed? Is that when the search starts to show changes in the range of D and above over the short and medium term?
Yeah, so I think there's different ways of explaining it. There's properties that pass, like I say, 48 to 49 out of 50 will pass. The 1 or 2 out of 50 that don't, it can be a stark as a fail, or it can be actually that there's further steps that are needed. And those further steps would be a discussion with a valuer, potentially a flood risk specialist, to ascertain their view as well. In terms of risk ranking, I think the categorization that Groundsure have on the first iteration of ClimateIndex, they're onto the second one already. So they're taking feedback, and it's all evolving, and they'll be bringing other geophysical risks into their product. But the first iteration was an A to an F, and an F is basically definitely problematic. A D is marginal, but heading that way, and so is an E. So it does vary, but they're looking at simplifying that into fewer categories, because this is a relatively new area. They're taking feedback and so forth. I know they're working quite hard on that at the moment.
Okay, thank you. Another question we have is, Stephen?
Yeah, here.
Sorry, I thought I lost you there for a second. Yeah, the next question is, if a search comes back that the property is at low risk, but then it does flood, for example, who would the client look to sue for negligence? The conveyancer for advising a low risk, or is it another body?
Well, what I know is that the Groundsure reports come with professional indemnity insurance. If there's any semblance there's been some negligence on their part, then it's backed by, I think there's £10 million of professional indemnity insurance, which is a possible avenue. I think you know, you stand back and you look at the different scenarios here. The properties low risk flooding doesn't mean that there's no risk of flooding. You know, extreme weather events possible anywhere in the UK, certainly for sort of surface flooding driven by climate change. So, you know, you've got to kind of stand back and look at their responsibilities and whether there's any prospect that they've been at fault, that they breached their duty or their contractual responsibility, and that you can bring a claim. But it won't always be easy. Just because there's been a loss, it doesn't necessarily follow that there's been negligence. So certainly looking at the search provider may be one route forward, but there'll be different options, I think.
Wonderful, thank you. That's all the questions that we have from our audience today, I believe. So I'm just gonna wrap it up and say thank you for joining us. I hope everyone found this session helpful and informative. If you do have any other questions about anything you've learned today, or if you would like some information shared with you, did we cover this slide? I believe we did. Anyways. Yeah, so contact information is on the screen. This session is being recorded and we will send you a copy so you can refer back to it. All that's left to say is thank you so much for joining us today, and we hope you have a lovely rest of your day.
Thank you. Bye, everybody.
Bye.